no one has plausibly made an argument that this is not the kind of person we'd want on the Supreme Court. The question then becomes, why is it so hard for the guy just to get a hearing and a vote? And this speaks to what's happened generally when it comes to the process of appointing federal judges. It used to be that people read the Constitution, and Article 2 powers fairly straightforwardly. It says the president shall make these nominations with the advice and consent of the Senate, and unless there was some sort of real problem with that judge's character or qualifications, it was fairly routine at every level, both at the district court level, the appellate court level, and the Supreme Court, that the person would be confirmed in short order. There'd be a hearing. People would ask the potential judge a question or two or 5 or 10. There'd be questionnaires. And once they had satisfactorily performed that process, then the Senate would vote. And it was presumed, it was understood that just as the president had a constitutional duty to make the appointment, that the Senate had a constitutional duty to at least make a determination as to whether this person should be on the bench. What has been unique in this process has been the growing attitude inside of the Senate that every nomination, no matter how well qualified a judge is a subject of contention. In some cases, it's simply because one party or the other wants to gum up the works, and so they will drag out confirmations longer and longer. Even if ultimately the judge gets confirmed by voice vote, by unanimous consent in the Senate, they'll drag it out for 2 or 3 months, because if you're bogged down with judges, then it means other business can't be done. So sometimes it's just strategic. In other cases, the view has been that despite all the talk about people wanting objective judges who are just calling balls and strikes and don't bring any views to bear, that there are litmus tests that are applied that prevent a judge from getting a fair vote, even though they're qualified, because they don't meet the particular views of the party that's objecting. And this problem got bad enough in previous administrations, but came to a head under my administration, in which we had a situation where we were starting to see 6 months pass or 9 months pass before a judge could get a hearing. This was when Democrats were in charge of the Senate, but because of the particular rules of the filibuster that previously had been used for just a few things, but now were routinely deployed on everything, we just couldn't get judges through. And you started seeing a crisis in vacancies across districts and circuits everywhere. Finally, the Democrats said, we're ending the ability for Senate members to filibuster when it comes to district court and appellate court justices, but we're going to preserve it for the Supreme Court. We now have a situation, after Judge Scalia's passing, in which it's not just that the Republican majority in the Senate intend to vote against a highly qualified judge. We now have a situation where they're saying, we simply will not consider the nomination itself. We're just going to shut down the process. And as a consequence, we have a 4-4 tie in the Supreme Court, and potentially at least 2 Supreme Court terms in which this vacancy will remain. That is unprecedented. Not only are they not willing to hold a vote at this point, they have refused to hold hearings on Judge Garland. And in some cases, Mitch McConnell and others have said, we will not even show the courtesy of meeting with the judge to find out what he thinks. And I think what's important for all of you to understand, because you're going to be not just lawyers appearing in court, potentially, but custodians of our legal system and our democracy, is if you start getting into a situation in which the process of appointing judges is so broken, so partisan, that a eminently qualified jurist cannot even get a hearing, then we are going to see the kinds of sharp partisan polarization that have come to characterize our electoral politics seeping entirely into the judicial system, and the courts will be just an extension of our legislatures and our elections and our politics. And that erodes the institutional integrity of the judicial branch. At that point, people lose confidence in the ability of the courts to fairly adjudicate cases and controversies. And our democracy can't afford that. Our system is designed to make sure that this branch works. And it requires a broad consensus, even if we don't agree on any particular ruling, that the court's rulings itself are legitimate and consistent with our democratic design. And that's why this is so important. It's not just a matter of who's occupying that 9th seat in the Supreme Court. It has to do with how we as a democracy operate and the particular authority that a court has to bring in order for our democracy to work. That was a really long answer. Others will not be as long.